It's my pleasure to be the moderator today for the 208th District Court. It's a pleasure to see all of you all here, and it's my pleasure to introduce to you our sitting judge of the 308th, James Lombardino, and the Democratic nominee, Jim Evans. And so I'm going to defer to you, Judge, and I'm going to flip a coin to see who's going to start first, and you make the decision whether you want to go first. Or have your opponent go first. So tell us. It is tabled.
I will let Judge go first.
All right. Judge, go ahead and do your opening statement, please.
All right, Mr. Evans, Mr. Garza, folks, thank you for having me here today. Actually, I think it's a good idea for family lawyers, for good judges to have this type of event. We see sometimes in the bar club, a lot of folks voting that don't have anything else, don't know anything about family courts. So this is, I hope, a group that will grow. I'm proud of the 308 and the changes we've made. One of the things I believe that is unique in our court is we do have our court rules on our website on the county. We also have them posted outside, and we have them posted. Actually, there's a list here. One of the things that's in our court rules is regarding amicus attorneys. We have a rule in our court where if you want an amicus attorney, if the parties agree, that's who we appoint. The idea in our court is to be cooperative, to be courteous, and to try and get the case settled. So if folks cannot agree, then of course we make the appointment. I'm also proud of the way that we do our mediations in our court. I noticed last night there was a lawyer that's very experienced in starting out doing mediation. She's charging $350 an hour, which is reduced from $500. However, in our court, if the folks do not agree on a mediator, we have mediators that are experienced and that will mediate in our court anywhere from $100 to $300 per side. So the folks that we generally receive in our court are what we call middle-class folks that really can't afford $500 a side. Now, the mediators we have are experienced, but they have agreed in our court to reduce their fee to $300 for a half day. And I think that has become an excellent tool for our court. And the reason, one of the things that we do in our court, we do require mediation prior to temporary orders, prior to final orders. And we do it sometimes at a reduced fee. The reason we do that is so that cases will settle. So in the 308, if you need a hearing, you can call up and get one in the afternoon that day. You can get the parties to agree. It's not on 3 days' notice. If you need a temporary order hearing, you can do it on 7 to 10 days' notice or shorter if you agree with the other side. There is not a delay in the 308 generally. And I'm proud of that fact, but one of the reasons we can do that is because of our rules on mediation. So we get the cases settled, and if not settled, then we're there. Judge Lemple and I, we're there. And you don't have a choice between the two. We're both glad to hear your cases, and they generally are heard the day that you're there. Thank you.
Mr. Evans, your opening statement, please.
Thanks. It's good to be here with Judge Lombardino and Mr. Garza. Thank all of y'all for being here. I appreciate this group putting this on, and all of y'all have invested time and money in being here. This is really important. Voters in our county, 1.7 million of them vote. More people that make intimate decisions about the family lives of the folks in this county, and most of those voters, I would say virtually all of them, almost 99% of them likely, have no idea who they're voting for. And your efforts to educate the public about who is running, who they should be voting for is really important. I'm very happy to be a part of this forum. My name is Jim Evans. I'm running for the 308 Family Court. I'm an attorney. I practice almost exclusively family law, except when a friend asks me to do something for them every now and then. Prior to practicing family law, I practiced bankruptcy law. And I will say that helps me a lot when I'm doing a complicated property matter. If I have experience with Chapter 11 bankruptcies, and there's virtually no property situation that I couldn't, that was presented to me in a Chapter 11 case that was more complicated than anything that I've seen in family law. I can untangle those matters. I'm also a dad. I'm an adopted dad. I'm a stepdad. I'm a divorced dad. I'm a gay dad. I understand the issues that come up in real life families, with real life kids, real life spouses, and real life ex-spouses. I am not running because I just got an interest in helping families. Before I practiced law, I was a school teacher, I was a minister, I have a master's degree in education. I want to make the courts a place where people in Harris County get good decisions made in the best interest of children. And they understand that they were treated fairly. There's no political shenanigans that happened in their case. Right now on the 308, the former Republican Party Harris County Chair people have been able to obtain enormous numbers of appointments. Is that allowed? Gary Paulin, of the $1.9 million that he's made off the county in the last 4.5 years, 19% of that was in the 308. Judge Lorardino has appointed Jared Woodfield more than any of the other family courts. I'm going to change that. I want people to be appointed if they have a reason to be appointed. I'm going to ask folks, which cases are you good at? What's your experience? What's your background? What's your education with regard to children? What can you offer to families in Harris County? Let me help you help families you can help. Let me make a court that is going to be good for the families of Harris County. My name is Jim Evans. Thank you very much.
All right, Mr. Evans, I'm going to pose the first question to you. What will be your policy on you or your associate judges, spouse, significant other, or other family members practicing law before your court if you are elected judge in this particular court?
Well, I don't have anyone of that sort in my life. So I will go to real good friends of mine, I'll say. I'm going to be impartial. I understand impartiality. I understand practicing law with real people as clients. When I have a client who's the person who shouldn't win, and it's apparent to everybody, I know that, the other side knows that, and maybe the judge already knows that. But my job as that attorney is to represent that person diligently, ethically, make their case as vigorously as it can be made. I do not want to win just because I'm friends with the judge. And I would hope that anyone who's a friend of mine, or a family member of mine that comes along later on, they wouldn't want to win just because they have a close relationship with me. I want to make the court a place of impartiality, and I promise to do so.
Judge, the same question to you. What will be your policy with regard to, for example, you have an associate judge or other family member that someone to the court? What will be your policy about having them practice law before your court?
Well, my son is a lawyer, but he practices labor law, so he's not in our court. The only one that would apply to would be Judge Lipton and her husband, Dan Lipton. And we do not appoint Dan Lipton in any of our cases. Except on occasion, there was one occasion where both parties asked for Dan Lipton, which we agreed to. I don't know that it's unethical. I don't know that it's a reason for removal. However, I just think it's a better practice that you not be appointed on any unless the parties agree. That's only happened one time in our court.
Thank you, Judge. Now, next question. Will you require those who you appoint as guardian ad litem or attorney ad litem for cannabis attorneys to personally perform the services that are required by the Texas Family Code?
I would and I do. That has been in the newspapers lately, and so we have doubled down our efforts to make certain that the person appointed is the person who visits the family. And when it comes to court, we've had occasion, I mean, all the judges have had occasion, where we appoint an attorney and they send somebody else for whatever reason. We're taking the position that is the only person that can get paid is the person appointed. If they want to send somebody as a substitute, they're not appointed on the case, they don't get paid. I don't think that's appropriate. I mean, we take care, especially in our CPS cases, on who we appoint and we match the people. And first of all, they have to have experience. CPS is very specialized practice, so we want somebody with experience. And so if we go to the trouble having, or experience having them there, we want them to visit the family, we want them to do their report, and we want them to appear. And we want them to appear on time. As you know, in our court, our docket starts at 9 o'clock, not 9:01. We take the attorney's time into consideration. I don't take breaks in the morning. Once I'm on the bench, I don't take breaks because I don't want the attorneys waiting around wanting to know when the judge is coming. And I think that answers your question.
Same question to you, sir. Do you require that attorney ad litem that you appoint, attorneys ad litem, or amicus attorneys personally perform the services that are required by the business?
Yes, absolutely. The code requires very specific things for amicus attorneys, attorneys ad litem, or guardians ad litem to do. We're going to require each attorney to do the work personally. You may have associates in your firm, you may have paralegals in your firm. I understand, I practice law too. If there may be occasions when the appointed attorney isn't able to make a phone call to set up the appointment to go see the child. But you can't bill for that. If you're not the appointed attorney, you're not able to bill times that then the county can pay for. I think one of the biggest problems is that attorneys, a small group of attorneys, get enormous numbers of appointments that requires then so much work that they can't possibly do it all. I think that a very simple remedy would be simply not appointing the same people over and over and over and over. If you have a large pool of people that are getting appointments in your court, I think that allows each appointed attorney the time that they're going to need to actually do the work that's required. And most importantly, this is in children's best interest. The code has laid out provisions that are intended to be safeguards for children. And when we are careless and allow ourselves to give appointments to a select few, it does not serve the people of this county, particularly the children of this county, well.
All right, final question. I'm going to pose it to you. In light of what's going on in this country at this time, what will be your policy if you're elected regarding limiting contact or periods of possession for a parent who tests positive for marijuana only?
Of course, laws may change, and I'm not in the position of a lawmaker. I'm in the position of a law knower and a law applier. And I intend to do that. Right now in Texas, it is illegal to possess marijuana. And I think if a person is in my court and they have tested positive for marijuana, we now know a lot more about marijuana medically, that it's not particularly as dangerous as I heard when I was in high school, because they said horrifying things to us. And I will disclose, I have never smoked marijuana in my entire life. I've never used any illegal drug, and no one ever believes me that it's true. I was raised in Deer Park by a conservative Southern Baptist. You know, I get it. But that said, I think that our law is very likely to change. When it does, the stigma that those people are going to have with me is that they don't have the judgment to follow the law. And if you have a bad judgment in that area, my concern is that you may not have good judgment in other areas of your life. And you may have a tendency to not follow the law in other ways as well. So that's going to influence my judgment. I can't obviously prejudge a case. I'm not going to say whether I will or won't give a particular fact scenario, possession time to a parent who tests positive for just marijuana. But those are I think I've given some guiding principles and some of my ways of thinking on that. Ultimately, I want to be fair. I want to hear all of the evidence. That's one piece of evidence that's going to come before me in that case. And I will rule in the way that I believe is in the best interest of children.
Thank you. And Judge, what is your policy in the 308 District Court regarding limiting contact or periods of possession for a parent who tests positive for marijuana only?
All right, first of all, when I look at these type of issues, the first thing I think about, should the state be interfering with this relationship and with the parent-child relationship marijuana. I've heard that read studies where it's more dangerous to have somebody that's an alcoholic than somebody that smokes marijuana. And each case, I think, is going to be fact. That is one of the factors you want to consider. You also want to look and see what the levels of marijuana is. Are they an occasional user? Or are they a chronic user? And I think that difference will come out in the evidence and how they treat their children, how they pick up the delivery, if they have insurance, when they're on their vehicle, again, their stability. That's what you look at. Certainly, I don't think the marijuana in my court, it doesn't make a difference just on that issue. However, it is one of the considerations that you have to look at because you don't want to, you want to protect the child.
Thank you.
Bill, you
All right.
have time for one additional question.
All right.
I'm sorry.
What unique trait, what unique trait do you bring to the court or have you brought to the court that you think is important that you should let the voters of this great county know about?
30 years of experience, first of all with the district attorney's office, then with a big downtown law firm, so I've got civil trial experience, I've got criminal experience, I've done bankruptcy work, and I had the experience I have my own 2 children. So I think it'd be very difficult in this job for somebody very young to do the things that need to be done in our court without the experience and the variety of issues, because on cases you need to know about the Fifth Amendment. You need to know what the rules are about evidentiary issues. And these things come out are frequent. The other thing is that our rules are a few things. First thing is courtesy. And I believe in courtesy. I believe that the lawyers ought to be courteous to the staff, and the staff ought to be courteous to the lawyers. In our court, we answer the phone. We don't take messages to call back later. You don't have to send an email. You get generally quick response. Normally, with our coordinator, Norma she's proud that in our court, the phone is answered, questions are asked, and we take care of our pro se's. That's another thing that I bring to the court. Our pro se folks, we take care of them that day. Our theory is if you tell the pro se to go do this or go do that, and harass them because they don't have an attorney, then they're just going to come back and take up more time. We don't do that. We try to take care of it if we can, if it's simple enough. And so I think that our goal is to be courteous to the attorneys, try to get through their hearings, try to have them timely so that they get on and earn a living.
Thank you, Judge. And for you, Mr. Evans, what unique trait from personal experience or professional experience do you believe that you will bring to the court?
Thanks. 2 things. I'm an educator, and I'm gay. And not one of those qualifies me to be a judge, but it does bring something to the bench that I think is going to be very helpful for Harrison County voters. I'm an educator. I've been a school teacher. I have a bachelor's degree in education. At heart, I want people to feel there's permission to change and get better. And the judge can't change people, but the judge can give people a sense of ownership of their own case. The judge can appoint people that are not going to, by the activities that are happening in the court, give off the perception that they're a political insider. People are not going to, if I'm the judge, walk out of court believing that it was a setup the whole time. I'm gay. Right now in Harris County, openly gay and lesbian people cannot adopt children. I don't know if that's because the judges, and I don't think this is true, I don't know if the judges really dislike openly gay and lesbian people, or if it's because they have a primary election problem, which means if they grant an adoption to openly gay and lesbian people, they will lose in the next Republican primary. If I'm elected, I will make those decisions based on the best interest of the child, which is what's required in the Texas Family Code. I'm not a one-issue candidate, but I will tell you that if I'm elected and you have an openly gay person that wants to adopt their partner's child, you can file that case. And if it lands in my court, I'm not telling you that I will grant it. I'm telling you that I will make my decision based on the best interest of the child.
Because I have okay. We're going to do closing, and I'm going to start with you. Your closing remarks.
Yeah, my name is Jim Evans. I'm an experienced family attorney. I'm a dad. I want to be the judge of the 308, not because I ever had any desire to be a politician, to run for office, but we need a change in the family courts. Litigants in the 308, if they are in a custody battle, are going to get one of the very select few people appointed as their amicus attorney or attorney ad litem. I'm going to change that. I'm seriously going to ask people to educate themselves, to do their own private CLE if need be. I'm going to have a booklet and say, please, I'm not going to ask people to do tests, but I'm going to say, please read this set of books. It's going to be things regarding brain development in children, how children develop in broken families, how children develop in established families. I want the bar, because we don't get experience in child psychology when we go to law school, to educate ourselves about these issues, because we are being asked to do things that we are really actually not qualified as attorneys to do. And we make decisions based on what we are predicting the judge might do, if the judge were to hear it, or we're making decisions based on our own just whim, or if someone has made us angry, so we have it in for them. I want us to be making decisions based on, I'm going to use the word scientific, but on a more scientific basis, on a more reasoned basis. I believe that that is in the best interest of children. I believe that families, when they see the way that the court has operated and the way that the appointed attorney has treated them and the value that's been added to their family system because of all of that, the amicus attorney acting appropriately and the court treating them with that new level of respect, is going to make a difference in their lives after that case is done. Because we see the case for a relatively short period of time. These people have to live together really for the rest of their lives, even if they are divorced. And I think that the court, by making very discreet changes in the way that it operates, can add value to the experiences that people have. We can't make them happy about it. We can't make them get back together. I'm not saying we even should. I'm a divorce lawyer. People can get divorced. I want the court to be a place where people feel like the system was a safe place for them to be as much as possible. I want to be the judge of the 308. I really appreciate y'all putting on this event. I would appreciate your vote and the vote that you're going to take, and actually I would like your vote in November.
Thank you, Mr. Evans. Big Lombardi.
Thank you, Mr. Evans. I'm proud of our court. When we got in there, you know, that our judge had been sick for a while, and because of that, there was the second highest docket. And of course, 2,800 cases. We now have about 2,000 cases, we're the second lowest. There's only one court that has less cases pending, and that's because we're efficient. We take care of folks. The allegation about this happening is very confusing to me. I don't know if it's about our court or another court, but in our court, like our local rules, our court rules are outside for reviewing. It's on our internet site for the county and post outside. Folks know their own case best. Parents should know best what's best for their children and for themselves, and the lawyers should know. So therefore, when they come in and they need advocates, they should be able to get together and choose one. And that's something on point, because we need to have both sides confident that the amicus is looking at both sides fairly. Now, in the event that it does happen on occasion, they cannot agree. What I do is I bring in the lawyers, I bring them up, and I'll go through a few names. And I'll wait to find somebody where they both agree. In my court, the amicus attorneys are not forced on any party. It's either done by agreement, or we go down a list and they can come to an agreement. Same thing with mediations. We try to accommodate folks because mediation is important. Anytime you go to trial, in my opinion, it's not in the best interest of the children. When you have litigation and there's a trial, it's just going to escalate things. They say for 12 to 15 years, things will be escalated among the parents. So what we want to do is we want to calm things down. We want to solve disputes and get cases settled. We do that by having competent folks, but folks that the attorney's agree to feel comfortable with. Mr. Woodfield, who he's mentioned, he's a family man, and he does get appointments in our court. A lot of Democrats get appointments. A lot of Republicans, I don't look at that. I want to know who's going to be out there looking at the children, looking at the best interest of the children, and those are the folks that I like, including Mr. Woodfield. And again, I would like your vote on Mr. Alden today. I'd like your vote at the election. And anytime you have a question about our court, you can come talk to Norma. If you have a problem, we try to take care of the folks. We try to take care of the attorneys. Because you know, when the attorney wants off on the case in our court, we let them off. We don't make them wait to the end of the docket at all. We let them off so they can get all their business for that thing. If the attorney needs a continuance in our court, and both sides agree, you just do a rule 11. We don't have them bring in for 15 minutes and have all the other attorneys wait around to see what's going to happen on continuance. It's 3-0. Again, I'm James Lombardi, I'd like to vote for 308. Thank you for your time.
Here's Lombardo, Mr. Evans, thank you so much